The great advantage of being the third to present is I can build on everything that was said before. Don't worry, there will not be a test. The disadvantage, of course, is that you've already heard from 2 lawyers, and I'm not sure you really want to hear from a third one, but I fear there's no way around that. Basically, I want to cover 3 points. I want to say, why are there dispute resolution mechanisms in trade agreements? I then want to explain the WTO system. Why the WTO system? Because that is the general standard model for all trade agreements that everyone departs from. And in fact, if you look at the reality of trade disputes are litigated in the WTO. They are hardly ever brought to regional or bilateral free trade agreements. I will not speak about investment disputes at all. And then finally, I will compare the EU and the WTO system using a practical example to drive the point home and to make this understandable, particularly to non-lawyers. And to make everyone feel at home, I will use Marmite, of course. Now, why do we even have dispute settlement arrangements in trade agreements? They are prevalent in almost all free trade agreements. In fact, the very few free trade agreements that don't have them tend to have one incredibly strong and one incredibly weak party. So you see where this is going. The resolution of the dispute is done by power relationships, but most have them. The WTO, Dispute Settlement Understanding, says the function is to provide security and predictability to trading systems. So you have an organ interpreting the law that is neutral and that does the job of interpreting. If it's a very advanced system, it will be an organ like the ECJ that can be somewhat more creative in its interpretation. If you look at the WTO, it's a very conservative interpreter. The early history of the WTO is basically the usage of the Oxford English Dictionary. Of all sources that they refer to, the Oxford English Dictionary to interpret the wording of the treaty was the most important one. To preserve the rights and obligations of the members, because only if you have a neutral instance to go to can your rights be guaranteed. If you don't have that, then you can complain to the other party, and the other party will say, well, we think a clause that says don't raise tariffs is complied with if we raise tariffs. And there is nothing you can do about it, no matter how absurd the statement. And then dispute settlement clarifies the existing provisions. Now, of course, you might not be convinced by any of this. Lawyers inherently find the existence of courts a natural phenomenon. Non-lawyers, not naturally so. Then one more incentive why there will be a dispute settlement mechanism in any free trade agreement with the EU. The EU has told Switzerland in no uncertain terms, we will block all further agreement on developing our bilateral relationship without having an institutional structure. So there's a limit to how far you can go in integrating trade without an institutional structure, and part of the institutional structure is a court. Now, what does dispute settlement look like in the WTO? And if we were in a public international law environment, I would say the WTO dispute settlement mechanism is one of the strongest ever conceived. But of course, we will compare it to the European Court of Justice, and so this falls by the wayside. Now, first thing, who can go there? Who can complain about what? Only members have the right to use WTO dispute settlement, that is, members of the WTO, which, for our intents here, will be states. Only states, companies, cannot use WTO dispute settlement, and they can go there, and again, I simplify a little bit, for complaining about breaches of WTO law. So basically, of trade law. And if you look at a trade agreement, you will see the provisions can be very broad. The WTO, for example, does not just have rules on trade in goods and trade in services, but also on sanitary and phytosanitary measures, technical barriers to trade, and intellectual property. you feel one of your partners is breaching the agreement, the state can go to dispute settlement. Dispute settlement is both binding, states are bound by the results, it's not voluntary, and states have to accept that mechanism. It's compulsory, unlike, for example, the International Court of Justice, where you have to agree for a case to go there. How does it work? The first step of WTO dispute settlement is consultation or mediation. So one party goes to another party and says, we think your measure, let's say they have raised a tariff, or they have a new labeling requirement that makes it really hard to export your goods, we think your measure violates WTO law. How does a country learn about that? Of course, it's the company that gets harmed that lobbies the state and says, oh, look, we have a problem here. Please, could you take that case to the WTO? Then the parties talk to each other. That's generally, there's a time limit for that of 2 months. And then party says, we haven't resolved it. We demand for a panel to be established. A panel is basically established ad hoc, consisting of 3 panelists, as a rule, who are picked from the trade community. Often trade lawyers, often people in the Geneva community. There's also a list, but the list doesn't necessarily mean that you will actually be appointed. That panel then has 8.5 months to come up with a report, and that report is adopted in a political body, but it's adopted by what is called negative consensus. So it will automatically be adopted unless everyone agrees it shouldn't, including the winning party, which you can imagine never happens. So the panel report will be adopted. And then there's the possibility of appeal. The appeal goes to what looks like a standing court with 7 standing judges. Currently there's an Indian member of the appellate body, a US member, a Korean member, a Mexican member, a member from Mauritius, from Belgium and China. Usually the US and the EU always have a member there. And appeals can only be filed on the basis of legal error, so not on any basis of factual error. That usually takes 3 months. Of course, in very complex cases like Boeing, it might take a lot longer, but these are the guidelines for the time periods. And an appeal can uphold, modify, or reverse the ruling of the panel. Now, what is actually the outcome? Because now we're at the outcome of the normal litigation. What do these reports say? They will say, for example, the measure that you've undertaken, description of the measure, breaches WTO law, bring your law into compliance. So they're statements of where there is a breach of WTO law, and then the state has to bring its law into compliance. The state has 1 month to state its intention to do so. And then it has a reasonable period of time to actually bring its law into compliance. Now, what is a reasonable period of time? You can disagree about that. In fact, you can arbitrate on the term reasonable period of time. After implementation measures are taken, you might disagree whether the state is now fully in compliance. Again, that can be brought to dispute settlement with slightly tighter timeframes, but dispute settlement. And then you might still be in a situation where no implementation is done. So the state that has violated WTO law, and there has been a ruling that it has violated WTO law, but the state says, yes, I'm sorry, I won't do anything. So what happens in those cases? First, there will be a discussion about compensation. So you say, you violated WTO law, we want at least compensation in some other field. Lower your car tariffs for your violation on beef tariffs. If that doesn't happen, you can ask for the possibility to retaliate, which is basically the WTO allowing you to retaliate in another field against the measure taken as an incentive to ultimately comply. Now, what does this mean in practice, particularly if we compare the ECJ and the WTO. The ECJ, you have direct effect and supremacy. Nothing like that exists under public international law. It's, of course, each state that decides whether it exists, but for WTO law, all states have decided. There's no direct effect. There's no supremacy. There's no standing for individuals. There's no violation action filed by the Commission. Only states can complain about violations of WTO law. And whereas in national courts you can get a measure annulled, in the WTO, the only thing you can get ultimately, if a state still doesn't comply, is the possibility to retaliate. So what does that mean for, let's say, a Marmite producer? Let's say a British Marmite producer wants to export to Hungary, and you can now think of various measures. The Hungarian president, it's a hypo, there is no Hungarian president, they have a prime minister. The Hungarian president decides that a law has to be passed to make imports of Marmite incredibly difficult. You can think of various reasons. Either they say there are health problems. We pass a law banning Marmite, we think it's unhealthy. For justified reason, or because he's married to a Vegemite importer. You can also think of a more technical reason. Marmite is just reclassified from a tariff line that contains protein concentrates, which is the current tariff line, to jam, and the tariff rises from 2% to 5%. This, by the way, is the constellation of Van Rent laws, a case in EU law in which the concept of direct effect was decided. What do you do under EU law? You go to a Hungarian court. You say, Hungary is violating EU law. You can directly appeal to EU law, and the fact that Hungary has passed a law is irrelevant. EU law is supreme over national law. Case decided. What is the result? The Hungarian measure is quashed. You can import the Marmite to the tariff that was agreed on in the free trade agreement. What is the outcome in a WTO-like system? Well, first of all, you as a Marmite exporter have no remedy in Hungarian court because you cannot appeal to the trade agreement because there's no direct effect and there's no supremacy. So instead, you will lobby the British government. For a lot of producers, that's the end of the story because they cannot successfully lobby the government. Some systems have set up legal facilities to do the lobbying in a more legal manner. The US has Section 301, the EU has a regulation, China has a regulation, a lot of countries don't. Now let's say you successfully lobby the government. The government brings a case. That case will be the case of the government because only the state has standing in the WTO. You cannot do anything. If the government decides to settle, out of your control. Let's say the government wins the case, but Hungary still doesn't comply. Then what do you get? In the end, the UK may be able to, in retaliation, raise tariffs on cars imported from Hungary. What good does that do to the Marmite producer? Well, he doesn't care very much. And Hungary stays in violation, but there's retaliation. Now, the point of this is to point out that there is some thinking here to be done on what you want. Of course, the ECJ is intrusive of sovereignty. Direct effect, supremacy have precisely that effect, but it is to enforce an agreement. There's much more effective enforcement. If you let go of that, you have more sovereignty, but that sovereignty is also a sovereignty to violate an agreement. I'm not suggesting, and in fact, there is no optimal solution. There's just choices to be made, and the choice is not entirely clear and preordained. Thank you.
Thank you very much, Holger.